I think it's an interesting case. So if you moved something from a taxable status in state 1, Minnesota in this case, to a taxable status in state 2, South Dakota, the assuming the Minnesota tax was paid at the initial purchase of the asset, when it comes to South Dakota, South Dakota would have the right to tax it, but would have to give you credit for the Minnesota tax that you paid. In this situation, no Minnesota tax was paid. So there was no offsetting credit. It was only used in South Dakota for a short period of time. So the argument that the taxpayer made was it should only be taxed based on the portion of the time that it is actually used in the state. We've got a lot of history of use tax not being apportioned. Richard Pomp and Jeff Friedman pro bono took this case to try to get it to go to the US Supreme Court even, which denied cert. And what they were trying to argue is, yes, sales tax shouldn't be apportioned because sales tax is a tax at the time of the transaction. Use tax is a tax based on use. And so why shouldn't use tax qualify for some sort of apportionment if it is something like construction equipment that is, moved across different jurisdictions? You can make the argument with vehicles, with a lot of different sorts of equipment that moves around regularly.